All right, Jeff, that snow came in, and it looks
Yep.
like as quick as it came in, it's kind of out.
It is out of here. A lot of melting took place, especially today, and we'll continue to see it basically disappear over the next couple days. Temperatures will stay chilly in the 40s, lows in the 20s, especially by, again, on Tuesday morning. Late week, we do have a warm-up. It's a brief one, back into the 50s with some rain coming with that as well. And then guess what? More cold the following week. Maybe some winter weather threats. We'll see.
Fantastic. Why not? Bring it on, I guess.
All right, thanks
Maybe
so
not.
much, guys. WAAY 31 gives you 24/7 coverage you can count on. Local news, breaking news, and severe weather. Don't go anywhere. LawCall is next.
This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight it's Ask Us Anything night, specially focused on the snow and ice we just had. If you experienced a problem slipping and falling at your home, slipping and falling at a business, slipping on the roadways, broken pipes leaking water into your house, fallen trees, space heaters causing fires, tonight's the night to ask us those questions. Call in your questions and you can be live on the air, 256-536-0077. You can also text us to that same number and we'll read your questions live on the air. You can also email us, and you can email any day of the week, any legal question. You send it to lawcall@waaytv.com. And when we get to a show that's on point, we'll pull some out. We've got some of your email questions tonight. Heath Brooks is here from Timberlake League and Brooks. Good to have you here.
Very nice to be here on this cold night.
You enjoyed the snow.
I did, yes.
It was beautiful.
Lots of sledding. I got a 9-year-old. We enjoyed some hills.
You had some good times.
Yeah.
But this also leads into your line of work. So personal
right.
injury cases, whether it's folks that got out and had sledding accidents, or they had traffic accidents,
Yeah.
or they had broken pipes. Tonight's your night to call in and ask some of those questions.
Sure.
We also have some video for you. We like to start off with You Make the Law Call video. We pulled this one. So a heavy freeze. Watch, we are about to have some snow and ice fall off the roof of this building. And it keeps coming, onto those cars. So when you see that, who do you think of as being responsible? Like the car owners, can they sue the building owners to say perhaps this caused damage to their cars?
You know, the first thing I think is that probably this is a situation where it's kind of geographic specific. There may be statutes in other areas of the country, up in New York, upstate the United States, up in New England, that requires buildings to take steps to get the ice off of their building.
Yeah.
If it's here, we don't really have the resources. We don't really know how to get up on a roof and clean. I think it would be more dangerous for somebody to get up on the roof and try to clean the ice off, in our kind of scenario, but we're not used to that kind of thing. But in this kind of scenario, what you want to make sure is if you have a car, you have good collision and comprehensive coverage on your car, so if something like that happens, doesn't matter whether or not it's your fault, whether or not it's the building owner's fault, your comprehensive insurance coverage will cover it in the event that your car is damaged. If it's a situation where the building owner should have addressed some, buildup of ice or snow on the roof that would be abnormal, then maybe you could bring an action against the building owner, but most likely that one's going to be on your insurance coverage.
Okay. A lot of times we see signs around. So the signs that warn not responsible for damage if ice falls off of off of the lines here and damage your car. Do signs make a difference?
Yeah, we see them on the back of dump trucks all the time. Stay 500 feet back. We're not responsible for anything that comes off of our truck.
Yeah, so does that mean they're not responsible?
No, it does not.
Okay.
You've got to secure your load. If you have something on the back of your dump truck, some gravel, stone, dirt clods, something like that comes off of your truck and falls on someone else or falls on the road, just because you put your sign up there that says you're not responsible, you as the truck driver are not the law. And so if you are negligent in the way that you secured the material on your truck, you could be responsible. We see it a lot with ladders, believe it or not. Everybody knows about the rock that hits their windshield. We don't know who to blame for it, and so we got to make a glass claim. But ladders on roadways that are not properly tied down on trucks, we see that a lot. And man, a ladder can cause a massive amount of damage.
Yeah.
Massive.
So if you could prove who caused it, you go after them.
You sure can.
If you can't prove who caused it and you hit a ladder in the middle of the road or something, what do you do?
Well, then you're going to have to take advantage of your own insurance company.
Okay.
If you have insurance on your car and it's just for the damage to the actual car, you would use your collision coverage on your car. If you got hurt, then you may have uninsured motorist coverage. And in Alabama, we call those types of claims a phantom motorist claim, meaning that there was a phantom motorist that was negligent in securing their ladder on the back of their truck or their car, and then that ladder came off their truck or their car and caused you an injury. You have uninsured motorist coverage in that scenario to take care of your injuries in a phantom motorist case.
Okay. We got an email question in from Anthony. Anthony wrote in, I had a big leak in my kitchen caused by the ice maker water line. My insurance is going to cover the damage, but they are insisting that the entire floor in that part of the house be replaced, not just the area around the water damage. I personally don't care if the new section of the floor doesn't match the old section. I just want this over. So do I have to go along with the insurance company's demand? Now, usually it's the other way, right? You want more done.
Yeah, I've seen this scenario before. And a lot of times we see it in the leak is in the kitchen, and then it migrates underneath a floor, and it gets into the bathroom, or gosh forbid, it gets into the living room, and then you have to remove all of the flooring in the living room, and you got to remove all the flooring in the bathroom. And so you come in and you tell an insurance company, hey, look, I don't want to replace all this. I just want to replace my kitchen floor. And the insurance company says, no, we're going to have to replace it all. I've seen that war between an insurance company and a homeowner or an insured. And the problem is that most of the time you get control of your house. You can tell the insurance company, I don't want you to replace this part of the floor. I don't want you to move past this area of damage. The problem is that if that other area of damage rots or has moisture in it, or they didn't get all of the damage, you can't come back later and say, I wish y'all had done it. Now will you pay for it? So the best course of action is if the professionals come out there and they assess your house and they make a determination they've got to replace certain areas, go ahead and do that, because you may kill yourself with coverage somewhere down the line.
Good tip. We've got Angela on the line with a question from Decatur. Hi, Angela. Thanks for calling. What's your question tonight?
Yes. Both of my parents have passed away, and we each own a fourth of the property. I would like to purchase the property. Do I have to have the other siblings to agree before I can purchase this property?
So who would you be buying it from? Wouldn't you be buying it from the siblings?
Yes, the deed is in each of us. The deed is out to all four of us.
Gotcha.
Okay. Yeah, so there's a couple of different ways that property can pass after your loved one passes away. And property will pass if it's in the will, which, Angela, it sounds like this property passed in y'all's will. It would either pass by what's called joint tenancy with the right of survivorship, meaning it automatically passes to the four of you, or if the will says you split it out equally, then it's most likely in a tenancy in common. And what that means is that all four of you you may own a quarter share of the property, but the property isn't divided out into fourths. And so, in other words, you didn't have a surveyor come out, divide all the property into 4 different sections, each one for you and your siblings. So in that kind of scenario, what you've got to do is either buy out the tenancy, buy out the other 3 owners, or y'all got to agree to break them up. What can happen in that kind of scenario is if you all cannot agree what to do with the property, then you would most likely ask the court would force a sale of the property, and then you would split the proceeds 4 different ways. And oftentimes, if you can agree with your siblings or whoever is getting the property how it's going to be split, or if one person can buy out the other, then it generally and can sometimes come down to the court issuing an order for the sale of the property, and then you split the proceeds 4 ways. You can buy it at that point in time too, but it would be on the open market for anyone else to buy as well.
Angela, have you talked with your siblings? Are they interested in maybe letting you buy or not?
There's 4 of us, and 2 of us want to, and the other 2 will not agree for nothing.
Yeah.
And we've been told that we have to go have this petition to have this done.
Yeah.
And then we've also been told that if one wants to do it, then we can have it done.
You can is the right word there. Yes, it is possible to have that done, but if y'all can't agree, then and you're dealing with land, most likely what a court's going to do is they're going to force a sale. Any one of you as a tenant in common, and that's the fancy legal term for it. You're each individual tenants in common because you commonly own a piece of property in shares. Each one of you can petition the court for a sale of the property. Oftentimes what will happen is that the judge will force a complete sale of the property and you'll split it 4 ways.
Good luck with it. We got this text question. Does a power of attorney, a durable power of attorney, override a will?
Well, durable power of attorney just lasts until the time when the person who has given the power of attorney passes away. So the two are basically distinct and have distinct powers. When you pass away, the durable power of attorney passes away with you.
Okay. We're going to take a break. We'll be right back. We've got some text coming in about delivery drivers slipping on the sidewalk. We'll be right back answering more of your questions. It's Ask Us Anything night.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Maservi. And hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
31 Law Call. I'm Sharon Doviet. It's Ask Us Anything night. Heath Brooks is here from Timberlake, League & Brooks. We've got callers waiting. We've got questions coming in, so you can call 536-0077. You can also text us at that same number, and we're getting a lot of text questions coming in, like this one. So someone texting says, I had a judgment brought against me for a credit card for $4,000. I'm 72 and on Social Security. I didn't understand what I was supposed to do, and I'd been sick, had pneumonia, so they won a judgment against me. What should I do now? Can they take our bank account or my car? I don't have anything paid for except about an $11,000 car in my husband's old truck. We live only on Social Security. So any ideas what she, I think it's going to be a she, can do about that?
This is some rows I've plowed before. Unfortunately, a lot of times we get a lawsuit in the mail. I saw this a lot during the pandemic. We get a lawsuit that is delivered to you, but somebody's serving you with a lawsuit. Take it. You don't know what to do with it. You put it in a drawer. Think it's just some sort of collection mail or junk mail. And then you get another letter somewhere down the road, or a sheriff shows up at your door with an execution, and you learn that not only was that not junk mail, but now you have a big judgment against you. And in your situation, it's $4,200, and you're on a fixed income. What in the world are you going to do? So there's a couple of different options, or really 3 different options I can think of right now that you could do in that situation. One is you may want to hire you a lawyer. And when you hire you a lawyer, what the lawyer will do is they'll file a motion to set aside that judgment, to say, look, I wasn't properly served. Maybe you weren't properly served. Maybe you didn't sign the paperwork right. Maybe they didn't go through the right steps to get a judgment. But you weren't properly served, or there are some circumstances where you can get that judgment set aside even if you were properly served, but you didn't understand the process. The second thing that you can do is, and this is an outside situation, but the second thing you can do is you can file for bankruptcy. Because in a situation where your assets are less than what you actually owe, then you file for bankruptcy, and the judgment creditor, that judgment against you gets discharged in bankruptcy. Now you're going to have to pay back a monthly amount to go through the bankruptcy, but you can get that judgment discharged in bankruptcy. The third thing you can do is you can contact the folks who got the judgment, because oftentimes these lawyers who do get the judgments, they don't want to take the steps necessary to execute on the judgment. I'll get to that in a second. But what you can do is call them and say, look, I owe this $4,200, or I think I may be able to work something out with you. Can I work? If you owe the $4,200, if you believe that this is a debt that you actually owed, you may be able to work out an agreement with them to where you can pay a small monthly amount and get that judgment taken care of. And then the last thing that you need to take note of is that if a judgment is executed against you, then what would have to happen is the sheriff would have to execute that judgment by taking your property. Now, they could take your personal property, but a lot of times there's some exclusions about what personal property can be taken, and so that's something that you may want to work through. And then the other thing is that your Social Security benefits most likely wouldn't be subject to that execution. So, and that's a fancy legal term for when they're trying to when the people who have the judgment are trying to get their money. That's called executing a judgment. My advice to you, though, don't just not think about it. Either hire you a lawyer, call the lawyers that have the judgment, take some steps, positive steps to get this taken care of, because it's not going to get any better.
Do you think they might also be willing to accept less? You know, if
Sure.
they've gotten a judgment for this amount of money, if you call them up, I wonder if they'd be willing to take less.
You know, you don't know, but that's the chain of communication. That's what I'm saying, is that your third step would be, let's contact these people. Let's talk to them about it. Let's get a line of communication. Hey, would you take this? I'm sorry I had this debt. Didn't know what to do. You know, I'm on a fixed income. Is there some way we can work this out? It's always better to open a line of communication with somebody than to try to put it in a top drawer and forget that it exists.
Yeah. If they're willing to take less, be sure that you get a written satisfaction of judgment
right.
when you've done $1,500 instead of what they
right.
set out.
Always keep it in writing.
Yeah. We got this text message. I have a heart condition, and my pharmacy has given me the wrong medication twice, 2 different times within a 3-month period. Each time the medication that was wrong, or that was given to me, could have caused detrimental effects. What legal recourse do I have? So it sounds like they didn't take it.
Well, you know, whenever there is medical treatment provided, whether that is in a hospital, whether that is by your regular family doctor, or whether that is by a pharmacy, that is considered medical malpractice under Alabama law. And so when you have a medical malpractice claim, it's kind of like baking a cake. You got to have all the ingredients to have a viable medical malpractice claim. You got to first have a breach of a standard of care. That means that pharmacy had to have acted wrongly and differently than any other pharmacy in the country would have acted. Providing you the wrong prescription for your heart medication would most likely be considered a breach of a standard of care. Then you have to have that breach of a standard of care have caused you your harm. Now here's your problem. You don't really have right now a harm. Thank goodness you don't have any damages. But if you had taken this medication and gotten sick, if you'd taken this medication, and I've seen situations where people go into shock, or where people OD on the wrong kind of medications that are provided to them. They have to go to the hospital. They have to have Narcan shots and things of this nature. And so that is a damage that is required to have a viable medical malpractice claim. The solution to your problem is change your pharmacy. And then the second solution to your problem, and I had to learn this the hard way by doing these cases over and over again, always, always, always check your medication. There are websites you can go to that will tell you what the size of your pill should be and the numbers of your pills should be when you get your pills. Always double check that with a website.
You know,
always.
I don't when I get some medicine in, but it could happen to any of us.
That's right. I mean, it really can.
Okay. Got a text message. I was injured at work and my boss was at fault. He's licensed and insured, but no workman's comp because there's under 5 employees.
Right.
Is he at fault for my medical bills? A log was dropped on my ankle and broke it. Surgery was required.
You know, the answer to that question is a definite maybe. So in the state of Alabama, we have a workers' comp statute that requires, and like you know, that requires your employer to carry workers' compensation insurance if you have over a certain number of employees. And if you don't have over a certain number of employees, you're not required to carry workers' compensation. But when you don't have workers' compensation insurance, what happens is you revert back to the old system. And the old system is from the early 1900s. And now your employer has to provide a safe work environment, cannot be negligent in the manner in which they're carrying out their work. So the answer to your question is that it's definitely possible that your employer could be responsible for your injuries and you would not be subject to the workers' compensation statute in the state of Alabama. That is certainly something that you would want to talk to a lawyer about and see what your options are in that scenario.
We've got Doris on the line with a question from Huntsville. Hi, Doris. Thanks for calling.
Hey, Doris.
What's your question tonight?
Yes, I was in the hospital, and this lady came by to borrow some money for gas. And I told her to, to look in my purse, and there was $20 that she could have. Okay, she stole my credit card and took the $20 too. I can prove that she stole it, or she got it out of my purse, let's put it that way. And I turned it over to the police department, and they say I can't prove that she done it. And there was nobody else in the hospital that was visiting me or even phone calls.
Doris, did she use the credit card anywhere?
Nursing home. And after I was in the nursing home, I had no phone calls or no telephone or anything like that, and no visitors. And now the police say that I can't prove that she stole it, but she also sent me $170-something for the booze that she bought on it, but not for the gas and the groceries and everything else.
So she used it. How much did she spend on it, Doris?
$179, but she spent about $1,000.
Gotcha.
Do you have the card back now, Doris, or has it been canceled?
No, it's been canceled, but the the card company wants me to pay it, and I can't afford to pay it.
So can't you call in and call your credit card company and say you've been defrauded, and usually they will reverse those charges for you?
That's right. You got to file a fraud report. You got to put this in writing. Make sure that when you send it over to your credit card, you let them know the circumstances. And if she's used the credit card and you've got a credit card statement showing use and it is not you and the signature is wrong, oftentimes these businesses will have video that will be right on the cash register, and that you can get those videos. Now sometimes those stores only have those videos for 30 days, so you got to move quick, and you got to make sure that they secure that video. But if you've contacted the police department and you've told them, hey, look, this lady stole my credit card, and they've conducted an investigation, that's one thing that they should do. And I would be asking the detective who was on your file if they have pulled the video from the lady fraudulently using your credit card, because that's the best way. But if she sent you a letter and sent you $170 back and said this is for the booze, but she still paid another $1,000, that would seem to be proof to me. Maybe you should give that letter to the police department.
We got this text question. My husband died 2 years and 7 months ago. For the first year, I kept getting bills from the hospital that the insurance didn't pay, so I paid them, and they said I wouldn't get any more. Well, now I've got a bill for over $1,500. Do I have to pay them? So husband died 2 years and 7 months ago. First off, we're sorry about that.
Yeah.
If you keep getting these bills, does the spouse have to pay?
Well, you know, that question is going to be, how was the estate set up? Because it wouldn't be, you're, as a spouse, you're not responsible for the bills of your husband unless you specifically said, I will take on that responsibility. And you would do that when you sign the paperwork at the hospital. And sometimes that does happen. But the second thing is that if your husband had an estate and that estate was set up and then closed, then the estate could have been responsible for any kind of money that would have been paid for the hospital bills. But if there was no estate set up, I don't believe you're going to be responsible for the bills of your husband.
We're going to take a break. Be right back answering more. It's Ask Us Anything night. If you didn't get your questions answered, here's how to get in touch with Heath Brooks with Timberlake League and Brooks, 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And Sharon does family law, that's divorces and child custody. She can be reached at 256-539-7337 or www.sharonfamilylaw.com.
Last text, if a delivery driver slips on my snowy sidewalk, would I be responsible?
You could be. New law in the state of Alabama dealt with a postal delivery person, slipped on some stairs. They were responsible, the homeowner was, because they had a duty to upkeep their property. Be careful.
Okay, good info. Thanks for all your questions. We'll see you next week.